You're watching Behind the Headlines. I'm Pacchia. As you may know, there's a debate in this country over what to do about the crisis in legal education. We have too many grads, not enough jobs, and everyone's carrying way too much debt. One of the prominent refrains in the current debate is the concept of caveat emptor. That's buyer beware. Students attending law schools should be fully aware of the risks, costs, and rewards of obtaining a JD, so the theory goes. That means doing due diligence, however, and my guest today says that some law schools complicate the due diligence process by making their marketing materials misleading. We're joined now by Ben Trachtenberg. He's an associate professor of law at the University of Missouri School of Law. He's joining us via Skype. Welcome. Thank you so much for joining us.
Thanks, Lee, for having me.
Of course. So you put out this really interesting paper on this topic. When we talk about misleading law school marketing materials, we're really looking at academic credentials of incoming classes and employment statistics for recent grads that have been misrepresented by the schools. Is that right? What else is misleading in their materials?
Yes. The most brazen examples we've seen of schools just straight up lying about the LSATs and the undergraduate GPAs of incoming law students. And then we've also seen a lot of what might be called more misleading and less brazenly dishonest reporting of the statistics of what our graduates do after they get out.
How widespread a problem do you think this is? Is it a small percentage of all law schools out there, or are we looking at something a little bit more widespread?
I think it depends on which angle of the problem you look at. If you want to know how many schools are straight up lying about the GPAs and LSATs of their incoming students, it's probably a very small number. I doubt it's only the two schools, Villanova and Illinois, who were caught doing it a couple of years ago. I can't imagine they're the only ones when you consider that more and more undergraduate schools and high schools and even grade schools have been caught manipulating data here and there. But I wouldn't say that's the huge problem we're dealing with. With respect to misleading marketing information, misleading employment statistics, an argument could be made that every single law school in America is at least in part responsible for misleading statistics, just because we don't even have the information necessary to be completely forthright. It's just often difficult. And that doesn't necessarily mean we're all blameworthy, but it means that it's difficult for a would-be consumer of legal education, in other words, a possible law student, to know exactly what's going on.
I think it's safe to say at this point we have a problem and something of a response already. Something like 15 law schools have already been sued for publishing allegedly misleading marketing materials. But you and your paper also think that individuals involved in these shenanigans should be brought up on ethics violations, not just lose their job, as we saw in the episode of Villanova and University of Illinois. How exactly would this work?
Well, the American Bar Association puts out model rules of professional responsibility, of professional conduct, and states adopt rules very similar to these. They don't have to, but the model rules are extremely popular. And basically every state has a rule that's identical to or similar to Model Rule 8.4, which says that lawyers shall not engage in deceit, dishonesty, misrepresentation, and so forth. And that rule is not limited to the practice of law. We already have rules that say you're not allowed to lie to the judge, that you're not allowed to lie to prospective clients, and things like that. This deceit rule is more broad, and lawyers, in fact, have gotten in trouble for doing things like plagiarizing a grad school paper when they went back to school after becoming a lawyer, or lying to the police, filing a false police report because some tenant in a building a lawyer happened to own was being annoying, or things like that. And lawyers have been disciplined. So in my mind, a lawyer who brazenly lies to a U.S. News and World Report, to the American Bar Association, to prospective students and anyone else about, for example, the quality of incoming students at a law school, that person should be at risk and indeed should be subject to professional discipline. And this would be a state issue. The state in which the lawyer is licensed would be responsible for dealing with it. But I think the case is pretty cut and dry for at least the worst actors. And the fact that we haven't seen any action even on those people is a little bit dispiriting.
But generally speaking, I mean, I know you have specific examples of times where people have gotten in trouble for ethical violations not directly related to the practice of law. But generally speaking, this sounds like something that just really isn't done. I mean, there are examples of very famous lawyers widely known to have engaged in deceitful conduct, and they still have their licenses. Is this a workable solution in line with the way professional ethics work in law?
Well, it depends on whether anyone wants to take the initiative about it. Part of the problem is that Bar Counsel in a variety of states is understaffed and is often going to be more reactive than proactive. They respond mostly to complaints from clients or other people who have a problem with the behavior of a lawyer, or if opposing counsel or a judge reports a lawyer for bad conduct in litigation. or a negotiation or something like that. So the lawyers who work in bar council offices, they're not going to be sitting around waiting to see if they hear a rumor about some lawyer engaging in deceit. But there are a lot of people out there who are pretty upset about the way law schools have behaved. Some of them upset enough that they've gone and filed lawsuits, which, to be perfectly honest, don't seem to have a tremendous likelihood of success for reasons we can get into if you want. But I think some of these cases have been dismissed wrongfully, but nonetheless they're gone. And so what you have is these people who think they're a victim of an injustice. They think the schools have engaged in deceit. And again, in cases like Villanova and Illinois, the deceit is in the newspapers. Everyone knows about it. This isn't really the kind of thing we'd have to build a difficult case. So the issue is maybe somebody who feels that they were cheated by such a school should file a bar complaint. Or maybe the schools at which these people worked should file the complaints themselves because they're, after all, in possession of all the facts, having done internal investigations. And I think if the complaints were filed, the bar council for the states in which those folks are licensed would be hard-pressed to say, we're not going to follow up.
Right. You're all over this issue, though. Have you filed a complaint, or do you plan to in the near future?
I have not filed any complaints, and I admit that almost every day when I get up, I have to wonder, is today the day I'm going to break down and file a complaint? I really don't want to do it because I think it's going to make it difficult for me to sound like I'm an academic on this issue who can be trusted to speak dispassionately. Then all of a sudden I'm going to be a lawyer who's advocating on behalf of my own complaints. But there's nothing stopping me from doing it, and I might. I think the people who are absolutely best situated to do it are those with firsthand knowledge. So everything I know about what happened in Illinois and Villanova is something that you could know as well. You could read the report that the American Bar Association or the Association of American Law Schools put out when they censured these schools. You can read the newspaper articles that were put out. You can read the report that, for example, Illinois put out itself when they hired outside observers to help them come up with the final facts about what happened. And so they're the ones, though, who have access to confidential information that I don't have. I just have the reports they put out. Now, I think what I have is enough to file a complaint, and I could do so. But it really is getting to be a little nuts that the folks who really know what's going on aren't doing anything about it. And if in the end it turns out that after my article is published and no one is doing anything about it, I end up filing complaints, that could be what happens.
But the people who know best, I would surmise, are also people who get their paychecks from law schools. Do you think that that's part of the reluctance here to get something like this moving?
It could be, although I don't think you're going to find anyone, for example, at Villanova who wants to stand up for the behavior of former Villanova Dean Mark Sargent and say he's the kind of guy who shouldn't get in trouble. But the story that you're going to hear, and that in fact you do hear, is this guy was a bad actor. We fired him and some other people for the outrageous conduct he did that's been detrimental to our law school, as well as, of course, other people in the profession and in legal academia and in universities, America, and so forth. So they don't have to say that legal academia is a bad place to file a complaint against this guy.
What do your colleagues make of your views on this issue?
Well, I'm not sure I can speak for all of them. I'd say I've gotten a wide range of reception. Again, there's very few people who are willing to speak up on behalf of the really bad actors. In fact, I haven't heard anybody stand up and say, well, Paul Pless did at Illinois, manipulating the spreadsheets so that the GPAs and LSATs would appear higher is okay. I haven't heard anyone really say that he shouldn't get in trouble or that they'd be stressed out if he had a complaint brought to the Washington State Bar where he's licensed. You get a lot more pushback on some of the other issues I raise, where, for example, I think that we do a very bad job of publishing honest and straightforward salary statistics. A lot of schools publish what they report to be the average salary of last year's grads, and collected at 9 months after graduation. And that data in almost every scenario is going to be misleading because folks who don't have jobs at all are not included. Indeed, anyone who doesn't have a full-time job is excluded from the subset. And even the folks who do have full-time jobs, it's only the people who either report their salaries to the law schools when asked, or for whom the law schools can figure out their salary based on public record. So, for example, if someone works at a fancy law firm that pays associates $160,000 a year, and the Career Services Office knows that that's what the firm pays, if someone's listed on that website as a first-year associate, we can write down 160 in the salary column for that person. But this leads to a skewing of the data because the people who work at firms that pay very little money aren't the firms that we know their salaries through public record. And I think that any law school that puts up a average salary, particularly if it's the mean as opposed to the median, so it's going to be even further skewed by those outliers in the 160 range, I think is being a little bit dishonest. Now, should those people all be subject to bar discipline? I had someone ask me at a presentation at a different law school when I presented this paper, but wouldn't that mean that the folks at career services at basically every law school in America could get in trouble? And I said, well, I don't know, maybe. That's not very popular. But part of what I'm saying is it's one thing to have made mistakes in the past and say, those were honest mistakes. I was doing what I thought was industry standard. It's another thing to say, now that it's well known that these statistics are misleading, I'm going to keep doing it. Maybe people who keep doing it are the ones who are putting themselves at actual risk of getting in trouble. Because part of the standard for dishonesty is you have to tell something that you know isn't true. Just messing up isn't the kind of thing that should get a lawyer in trouble under Rule 8.4.
Do you sense, given what's happened in the last couple of months, that there's any real reluctance on the part of disciplinary authorities when we talk about the specific issue of filing ethics actions against representatives of law schools that have published misleading marketing materials?
I don't really know. I mean, in part, my article is forthcoming. It's coming out in Nebraska Law Review in June of this year. You can get it online now on SSRN and elsewhere. But because in part it's a work in progress, I'm not busy mailing it to every disciplinary authority in America. When it's out and I have paper copies, I'll probably send it out to more people who might be interested, and I'll see what they have to say. But I haven't heard anyone express reluctance exactly. It's just that people aren't jumping to do it, in part because so many of the law schools have the plausible sounding defense that what we do is vaguely like what most other law schools do. But that's not always a defense, right? If we have a law against a certain kind of securities fraud, somebody's going to be the first one to get prosecuted. And if her defense is, I thought everyone on Wall Street did that, well, that might be a defense, but it might not.
No, we'll have to leave it there for now. Ben Trachtenberg, really interesting paper. It's a bit of a mess, but hopefully you'll come back and talk to us about developments as they come out. Thanks so much for your time today.
Thanks very much. I'd be happy to.
If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.